Hello guys, this is Olayeni Dieko Daniels, popularly known as Dieko Spectre. And on today's class, we would be talking about what a crime is from the Dieko Daniels School of Law. Now, in my previous class, I introduced to you what exactly criminal law is and the purpose for criminal law in our society. And I also told you that the essence for studying criminal law as law students is so that when we are called to bar eventually, we would prosecute certain people or defend certain people when they are being brought before the court of law. Now, when you are in court, what will be regarded as a crime which the court will adjudicate upon? Do you understand? And that is what we will be discussing about today. What exactly is a crime? So, if this is your first time of coming to my channel, listening to my lecture, I want to say a very big welcome. Please make sure that you click the subscribe button and also click the notification bell so that anytime I release any video which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. So today's lecture, we will be discussing what a crime is, and then we go straight to my notes. The word crime is derived from the Latin word crimen, meaning an accusation. I hope I pronounced the word crimen properly because I don't speak Latin, but you get what I'm talking about. Now, in both the criminal code and penal code, use is made of the word offense rather than the word crime. But since the adjective criminal is used in both codes and the Constitution, the word crime and offense would appear to be interchangeable. In fact, Section 1 subsection 2 of the Criminal Law of Lagos State, now note that the Criminal Law of Lagos State is the primary legislation governing crimes in Lagos State. We have the Criminal Code and we have the Penal Code. Now, for the Criminal Code, like I told you in the last class, it governs the 17 southern states. Now, those are the 17 southern states that have not had their own state legislation. The reason states can have legislation on criminal law is because criminal law falls under the concurrent list as opposed to the exclusive list in our 1999 Constitution. Therefore, where there is a state that has made a law on crime, that particular state law would be binding. Do you understand? Now, according to Section 1 subsection 2 of the Criminal Law of Lagos State, it provides that offense may be used interchangeably with crime in a law or regulation, and even the courts use both terms indiscriminately, and they would be so employed in the course of my lecture, both in this video and in subsequent one. Now let's take a brief history as to the codification of criminal law in Nigeria. Now, in the last few decades of the 19th century, an attempt was made to codify the common law. The draft code by Sir James Fitzstevens in 1878 was modified and adapted as a criminal code for Queensland, Australia in 1899 and the Protectorate of Northern Nigeria in 1904. Now, what does this mean? It means that before we had a code in the world, not even in Nigeria, in the world, criminal law was regulated by judicial proceedings or judicial pronouncements. Do you understand? It means that there was no book like we have now. Now, if you want to say, oh, the law against murder, go to section this. The law against rape, go to section this. The law against armed robbery, section this. And stuff like that. Before that, if you wanted to say the law against murder in the case of A versus B, there was no code that regulated criminal law in Nigeria. But after, and that was what necessitated this particular person, James Fitzstevens. He brought all, at least as much as he could find, criminal proceedings and adjudications by the court. He brought them and codified them and such codification was modified and adapted as the Criminal Code in Queensland in 1899. Note that he wrote it close to 20 years prior that time, that's 1878, but it was adapted in Queensland in 1899, and it was now adapted again in the Northern Protectorate in 1904. Do you understand that? Now, following the amalgamation of the colony and protectorate of Southern Nigeria and the protectorate of Northern Nigeria in 1914, the Criminal Code, which was applicable only to the North by virtue of the 1914 structure, now became applicable to the whole of Nigeria. In 1959, the Northern region of Nigeria repealed the Criminal Code and adopted the Penal Code, which was modeled after the Maliki law and the Penal Code of Sudan and India. Thus, at independence, that is in 1960, the Penal Code applied in the Northern Nigeria, while the Criminal Code applied in Western Nigeria and Eastern Nigeria. Today, the Penal Code applies in 19 states, like I said earlier, while the Criminal Code applies in 17 states of the Federation, save to the extent of those states that have decided to have their own law regarding criminal law. For example, Lagos. Now, when we are defining what an offense is, like I said earlier, an offense, a crime, they are used interchangeably. When we are defining it, section 2 of the Criminal Code says an act or omission which renders the person doing the act or making the omission liable to punishment under this code or under any other in council, ordinance or law or statute is called an offense. Now, in this definition, I want us to bring out 3 elements. As a criminal law student, you must always know that there have to be 3 elements when you are talking about what an offense is. Number 1, an offense can be an act. That is a positive act of doing something. Not just that, an offense can be an omission. Note that when we are talking about omission, I will discuss it more when I'm discussing actus reus. But when we are discussing about omissions, you know, the act, the guilty acts, there are certain omissions that would not be regarded as a crime. For example, someone's house is burning and you are walking past it. The omission to go and help put out the fire, is it a crime? Should it be a crime? If somebody is currently committing a crime, maybe robbing a bank or doing something, and you have the ability to stop it, but yet you just decided to overlook it, should that be considered as a crime? Things like that. So, but that's what we will be discussing in my class on actus reus, act and omission. This particular class, we just want to know the overview of what a crime is. And I told you that an act, number 1, could be a crime. An omission could be a crime. But the most important thing when you are discussing about what a crime is, you have to go to the latter part, which renders the person doing the act or making the omission liable to punishment. Which means for any act to be a crime, there must have been an act or an omission which is punishable. And not just that, it must be written in a law. It must be written in a law. You must have an act or an omission that is written and has its punishment attached. Those are the 3 elements to form a crime. An act, an omission, written with a punishment attached. The moment you have those 3 elements, then that is a crime. Do you understand that? Now, there are 2 cases to that effect, which number 1 will be the case of AOKO and FAGBEMI, and also the case of UDOKWU versus ONUGHA. Now, in the case of AOKO and FAGBEMI, if you want to read more of these cases, like the court judgment and all that, you can download Precious Case app on your phone and you have easy access to the cases and you don't really have to stress so much. But I'll just give you a brief of AOKO and FAGBEMI, and it's so much of a locus classicus or not what exactly we are talking about. So in Northern Nigeria, adultery could be a crime. You know what adultery is. Adultery is when you are married and you still fornicate, you still go out and sleep with other women and all that. But in southern Nigeria, it is nowhere in our criminal code. Now, in the case of AOKO and FAGBEMI, something very interesting happened. The prosecutor charged the person to court in southern Nigeria using southern criminal code and saying that that person has committed adultery. And then the question that the court had to answer, what will then be described as a crime? A crime has to be an act of omission which is written in a law with its punishment attached to it. In this case, is there any law that says that adultery is a crime? It's not that the law has to say adultery is hereby a crime. No. The law has to tell us what will constitute adultery. What is that act that will constitute adultery? That's number one. Number two, the law also has to tell us what would be the punishment for that particular act. So you can say that first of all, the law has to be written. The law has to tell us what act or omission will amount to adultery. And the law has to give us the punishment. When those things are satisfied, then you have a crime. Do you understand that? Now, if you look at section 28 of the penal code, it tells us that except where it otherwise appears from the context, the word offense include an offense under a law for the time being in force. Section 3 talks about punishment of offenses. Every person shall be liable to punishment under the penal code for every act or omission contrary to the provision thereof, which he shall be guilty within the northern Nigeria. After the commencement of this law, no person shall be liable to punishment under any native law or custom. Now you can see this further tells us a little bit about our element in the definition of a crime. Read the latter part. After the commencement of this law, no person shall be liable to punishment under any native law or custom. Do you understand that? It means basically that witchcraft, which could be a punishable offense under any native law, would no longer be regarded as a punishable offense under the criminal law, except the criminal law criminalizes witchcraft. Do you understand? There are certain things that under our customary law would have been an offense before the introduction of the criminal code, but now it is no longer an offense. The fact that the society frowns at that particular act, for example, adultery. The society frowns at adultery. When you are married to a person, you should not be sleeping around. You are supposed to stay with your married wife. The fact that that is morally wrong, the fact that the society frowns at it, does not make it a crime, except the three elements of a crime are therefore fulfilled. Once they are fulfilled, then it is a crime. Do you understand that? Now, when it comes to the purpose of criminal law, I already discussed it in my last class. However, for the purpose of convenience, when you look at section 2 subsection 1 of the criminal law of Lagos State, it gives us a better perspective as to how and why we need to have criminal law. A will tell you promote an orderly society, which I told you in last class. B will tell you foster collective obligation and duties towards the preservation and protection of life and property, including public property. Now, when you look at B, you can put NSAS in context. Criminal law will tell you that when you are protesting, protest well. Protest, you can shout, you can do anything you want to do, but do not destroy properties, including public properties, because the moment you start doing that, you are beginning to commit a crime. That then can be regarded as destruction of properties or riots or insurrection and things like that. So the law does not criminalize protesting. You can air your view, come together, carry placards and air your view, but do not destroy properties. Do you understand? Also, forbid and deal with conduct that unjustifiably and inexcusably inflict or threaten substantial harm to individuals of public interest. D. Subject to public control persons whose conduct indicate that they are disposed to committing offences. And then when you look at others, it gives you a better perspective of how and why we have criminal law. In my next class, we then have to look at, very importantly, what are the elements of a crime. When I mean the element, What are the things that are to be proven in a crime before we can say that that person is guilty? In this class, we looked at what a crime is. What are the things that must be in a crime? What are the things that we must have before we can say a particular act is a crime? That's the question. And I have answered that we need to have three things: an act or omission, punishment, and written down in a law. When you are talking about whether or not it's written down in a law, also don't forget that there was a time the AG of Nigeria, as of 2021, said that Twitter has been banned, and anybody who still uses Twitter, even when it had been banned, will be prosecuted. When he said this, I laughed. The reason I laughed is because as the AG of the Federation, I think that one of the first things that you will learn in criminal law is that you will have to make sure that that law is written down before it can be enforced as a crime. He didn't say you will be sued. He said you will be charged and prosecuted. How do you charge a person for using Twitter when it has not been written down in a law in Nigeria? It need not be in the criminal code. If the House of Assembly of Lagos State or the National Assembly has passed a law to the effect, then fine. But you can't just wake up one day in your office and say, yes, my fellow people of Nigeria, because I don't like the fact that we proscribed Twitter and you people are still using it, I will therefore prosecute, charge anybody that uses it. I mean, the first thing in criminal law to understand is that that is just a joke. Do you understand? So in my next class, we will be talking about the elements of a crime. When somebody has committed a crime, so to say, what are the things that must be fulfilled? What are the elements that you must prove or disprove in court, for you to either succeed in putting the person behind bars or succeed in properly defending the person to be discharged and acquitted. And with that, I will see you in my next class.